Good afternoon, good evening, good morning to those of you who are joining us. We are about to embark on an hour and a half discussion with these three distinguished panelists whom I'm about to introduce. And the topic is the relevance of the recent ICC decision to claim jurisdiction over the situation in Palestine and what that means, what the complexities of this decision are, and how it may affect the debate around the standing of Palestine in the international community. We have a distinguished panel. Our first guest is Professor Ioannis Kalpouzos, who has extensive legal experience with the ICC and is an international criminal lawyer. And he is currently at Boston University, but he also has a standing appointment in the UK as well. Our second participant is Professor Richard Falk from Princeton University, who is a renowned scholar on the ICC and has been very influential in the debates that have gone on about the standing of Palestine in the international community. And he also has an extensive history in terms of human rights advocacy and issues around nuclear weapons. So look at his bio, but he's positioned to speak particularly well today on this topic of Palestine. And then our third panelist is Ms. Rania Muhareb, who is a legal consultant to Al-Haq. Al-Haq is one of the foremost human rights organizations in Palestine and has a long history of dealing with extensive legal issues, both human rights and international humanitarian law in the Palestinian context. And she is one of the lead analysts in the recent report that Al-Haq has produced around human rights and health issues in Palestine. So we now, I hope, can begin. And Ioannis, could you start by speaking to us about the context of the ICC decision, the legal context, whether Palestine is really a state under public international law and how that plays into the Rome Statute and the jurisdictional questions. And perhaps also an overview of the Palestinian case that came in 2015, which actually prompted the inclusion of Palestine in the Rome Statute and where the court said it had jurisdiction over Palestine. So there's a number of steps that I'm hoping you can explain to the audience. You have 15 minutes and it will be uninterrupted. So please, the floor is yours.
Thank you very much. And thank you so much for the invitation. And it is an honor to be part of this panel with such distinguished colleagues. So yes, I'm happy to try to give an overview of the case from a very specifically international criminal law angle, right? Both in the context of the role and function of the international criminal law regime and specifically in relation to the institution, the International Criminal Court. So the prosecutor last week announced formally, as we know now, that an investigation is beginning into the situation with a view to determining specific crimes and specific cases. And in her statement, perhaps also responding to some of the quite heated rhetoric that followed the decision of the pretrial chamber on jurisdiction, she pointed out that International Criminal Court is no panacea, right? And that all it could do is to investigate the crimes under its jurisdiction. So I think that's a good place to start because the nature of international criminal law and International Criminal Court sometimes may suggest and might lead to the impression that it can be a panacea, and that it can have a function which is perhaps outsized than its actual importance. So there is an interesting combination in relation to international criminal law as a legal regime in general, and its application by specific institutions, which is that on the one hand, it has a certain ambition and promise of universality, an appeal to both fundamental moral values, but also a emerging system and concept of the rule of law and the international order. And therefore, people, both lay people, but also experts, are inclined to place a lot of hope in that regime in terms of addressing evils, in terms of righting wrongs, and so on and so forth. And indeed, the institution, the International Criminal Court, being the first permanent and with potentially universal, but not actually universal jurisdiction as a court, as a criminal international criminal court, embodies some of these promises. But in practice, this is not borne out. And this has been the history of international criminal law, that it has been applied selectively. It has been applied selectively in terms of the creation of specific institutions, in terms of the activation of the jurisdiction of existing institutions, and even to the extent that we are, and we're talking about, and we have a court like the ICC with potentially universal application, in terms of the selective application of and activation of the jurisdiction of the court. And the way that international criminal law has worked historically has been, and it's easy to be a little bit too cynical about this, and I don't want to be too cynical about this, but has been primarily on the side of the powerful and as against the powerless and the weak, right? Either through precedents where international criminal law has been created through victor's justice, either through precedents where it has been a tool of the Security Council, or especially in relation to the application of the law of the International Criminal Court in situations that occur in states that are relatively weak. And potential inequalities or asymmetries are really built into the legal regime of the International Criminal Court. And I will try to touch on a couple of those, but it's something that I think is important to keep in mind when we do appreciate the consequences and the effect that this decision will have. They are built into the particular crimes that are included. They are built into what is necessary in order to prove these specific crimes. They are built into the legal regime for the activation of the jurisdiction of the court and the admissibility of cases, specifically the regime of complementarity, on which we might have something to say in a little bit. And they are also primarily and fundamentally built into exactly over whom and where the court has jurisdiction, which allows certain states to some extent escape the jurisdiction of the court, to not ratify the Rome Statute and to not be subject to the jurisdiction of the court, and be powerful enough to not be under pressure in order to do that. And as is the specific case here, it also limits the appeal to the court and the granting of jurisdiction to the court and the triggering of the jurisdiction of the court to states. So it is part of this struggle, if you will, to appeal to that particular authority and the enforcement of international criminal law through that particular authority, that the contest over statehood is being fought in this instance. And that is inscribed in certain ways in the evolution of the legal struggles in relation to Palestine and the role that the assertion of statehood has played in those struggles. And the hopes that have been placed, sometimes in a strategically sound way, sometimes perhaps not in the recognition and the actual application of statehood in this context. And I think this is reflected in the evolution of this case. Palestine initially accepting the jurisdiction of the court in 2009, the then prosecutor of the ICC taking a long time and not necessarily responding clearly on what they were planning to do, but ultimately in 2012 rejecting this application on the basis that Palestine is not, or at least on the basis that it is not up to the court to say that Palestine is a state, and specifically relying on the fact that Palestine was not at this stage a non-member state in the General Assembly, but only an observer, and that the matter was still before the Security Council, but as we know, the Security Council had blocked the process, which then led to the next step, which was the admittance of Palestine to the General Assembly through Resolution 6719 in November 2012, which changed the status and added a specific institutional form of collective recognition alongside the nexus of bilateral recognitions that Palestine had already benefited from, which together with the change in the personnel of the prosecutor's office, the move to a new prosecutor, Fatou Bensouda, who in some ways, and perhaps that might also be something that is worth discussing later on, has started charting a different course than her predecessor, and whose term also comes to an end this summer with a third prosecutor taking over, which will be also an important factor in moving forward. The issue was reactivated. And the decisive step in order to reach the decision and the position that we are in now was the formal accession of Palestine to the Rome Statute in January 2015. After that, the prosecutor continued to develop the preliminary examination on issues that had to do with whether there is a reasonable basis to believe that certain crimes have been committed, as well as on issues that had to do with questions of jurisdiction, and determined that indeed there are such reasonable grounds to believe that there is a matter for further official investigation, moving on from the phase of the preliminary examination, but recognized and perhaps also felt the need to appeal to a certain support and legitimacy in relation to some very controversial issues, namely the question of statehood. And therefore, as we know, in the beginning of 2020, appealed to the court and asked the court to determine and confirm the existence of jurisdiction on the basis of Palestine's statehood for the purposes of the Rome Statute. And the argument that the Office of the Prosecutor made in this request is, I think, significantly mirrored in the decision of the court. It relied primarily on a narrow argument of statehood. So it sought primarily to avoid entering some conversations in general public international law over the statehood of Palestine, and specifically over the application of the so-called Montevideo criteria of statehood, and thereby avoid debates over, for example, whether the nature of the borders and the fact that the specific borders are still under negotiation, whether that has any effect on the statehood of Palestine, or perhaps more crucially, whether the limitations in the effective control, or indeed the split nature of governmental control between Palestinian Authority and Hamas have on the existence of formal statehood, or indeed to take into account the countervailing power of the principle of self-determination in terms of determining statehood. So the prosecutor and ultimately the majority did not want to go there, to put it in this way. So the prosecutor advanced the argument of general statehood only as a secondary argument, and advanced the primary argument of a functional statehood specifically for the application of the Rome Statute and the application of and the jurisdiction of the International Criminal Court. And that argument, which was indeed the argument that was accepted by the majority of the opinion by the pretrial chamber of the International Criminal Court, was that statehood followed the decision of the General Assembly, followed the power that Palestine has been granted through that decision and through the Secretary General of the United Nations with respect to signing and ratifying treaties. Indeed, the fact that Palestine has in that time signed and ratified a number of treaties, and that in that context, it has signed and ratified the Rome Statute of the International Criminal Court. And on that basis, secondarily, has been accepted in the Assembly of State Parties. The majority also made the point that the states that constitute the Assembly of State Parties did not object to the accession of Palestine to the Assembly of State Parties and to the Rome Statute. I think with the exception of one state, Canada, and that included states that submitted amici curiae that challenged the statehood of Palestine in that particular context. But I should note that that particular argument is again secondary to the primary argument, which is the General Assembly status and the general status of the capacity of signing and ratify treaties. So it's wrong to say that the argument of the court is that by silence and acquiescence, functional statehood was given effectively by the Assembly of State Parties. And on that also functional and narrow argument, as we will hear more from Professor Falk, the question of the potential limitations of the Oslo Accords was also sidestepped and was not directly addressed, right? Because it was not a reference to the general nature of the statehood, the sovereignty, the jurisdiction that Palestine was granting to the court, but very specifically the notion of the functional jurisdiction as accepted by the Assembly of State Parties. So this is the result, and this led to that majority decision and the decision of the prosecutor to activate officially a formal investigation into potential situations and crimes. So to conclude, I'll just highlight very quickly the two, as it were, next important substantive points that this leads, and I'm happy to discuss them in more substance upon question and answer. The first one is that according to Article 18 of the Rome Statute, now the prosecutor will address states with primary jurisdiction in order to initiate a cooperation with these states in the investigation of the crimes. And this will include Palestine, and it will include Israel. So in that context, various questions arise. One is the degree and extent and type of cooperation that both parties will grant. And while in terms of statements, Palestine and relevant Palestinian authorities have quite openly said that they will cooperate, Israel has officially and formally held a very negative position, and we can discuss this further, what that might mean. Secondly, this will potentially activate the principle of complementarity, which is that the court will exercise its jurisdiction only if domestic jurisdictions are, states with domestic jurisdiction with primary jurisdiction are unable or unwilling to do so, which is to put it very simply, where the game is at in terms of who will take the priority and be either address or be seen as addressing specific situations. And finally, the question remains on which specific crimes the court will look at in its preliminary examination and its application to the court. It has highlighted certain situations: the 2014 war in Gaza, Hamas rockets, settlements, the 2018 targetings in the context of the Great March of Return, as well as one or two other potential situations. The question of the use of torture in some instances by different actors may have been highlighted. And it will really be a very complex and time-consuming, because this is a very long time development, and it's important to have that in mind as well, alongside with the avoidance of believing that this is a panacea. We will see over time exactly how this will play out in this context. Thank you very much.
So, Ioannis, thank you for a very robust discussion. I feel as if I'm listening to a commentator on a very fast-moving soccer field. You know, knows all the players, knows what the moves are, knows what is going to come next, and can anticipate and explain to people the next three moves of various players. But it's excellent to have this background, because there is this tension, isn't there, between who was at the table, who was not at the table, who is going to be pulling strings in the background, who is not, whether there will be sort of a coherence around this notion of the general applicability of what it is to be a nation state, or at least a state. I mean, these nuances are very important for us to recognize in terms of the dynamics of not just the court, but of how criminal law unfolds, international criminal law. So thank you for that. We'll come back to several things at once when we get into the mix-up of the question and answer. Professor Falk, or Richard, if I may, now having heard what Ioannis is saying, and also knowing that we are hoping you will talk in somewhat more detail about the relevance of the Oslo Accords to this decision, the floor is yours for 15 minutes, and thank you very much.
Well, thank you, Jennifer, and I'm very happy to be part of this panel, and I think the issues we're discussing are extremely important for the future of international criminal law, the future of the International Criminal Court. It's a strategic moment, I think, for the rule of law globally, because as Ioannis very comprehensively depicted, the application of international criminal law has basically exempted the geopolitical actors. Some have said of the UN itself, it's very good at imposing accountability on the weak and completely impotent when it comes to accountability for the strong. And of course, the dangers to the world come more from the strong than the weak. So it accentuates this underlying problem. And just to add a couple of institutional remarks to what Ioannis presented so clearly, I would say, first of all, that what's at stake here is how much you can stretch the legal approach to behavior in the face of geopolitical defiance. So Israel has reacted not as if it was prepared to engage in a substantive debate about whether the decision was well grounded in law. It has tried to dismiss the decision. Its leader has tried to dismiss the decision, in his words, as pure anti-Semitism, which is a kind of way of saying international institutions and international law do not apply to our kind of sovereign state. And the US has more or less gone along with that line of response, saying this is politicizing the court. And if you follow that kind of reasoning, it's politicizing it because it's trying to hold accountable a state that is a close partner of one of these geopolitical actors that's above the law. See, that's what makes this such a dramatic context, is whether this status of being above the law can be challenged effectively. And it's important to appreciate that in the past, the International Criminal Court has been criticized because it's only gone after the weak. It's only gone after African countries, and there are a few marginal exceptions to this. And it has created the impression in the non-Western part of the world that this is a kind of post-colonial way of maintaining Western hegemony by way of law and morality. And so it's very important for the legitimacy of the court that this decision has gone the way it has. And it's important to appreciate that the decision at this point is only to investigate allegations of criminality made by Palestine. And it's important to recognize that the court is not proceeding only against Israel. Hamas is also alleged to be, there's alleged to be evidence that its use of rockets was not targeted toward military objectives, and therefore it was violating international law through the way in which it purported to resist the Israeli attack in 2014. And some fear, actually, and this is a political fear, that it will prove easier to establish the Hamas violation of international criminal law than these Israeli violations, for which evidence connecting perpetrators to the events might be quite difficult to establish given the refusal of Israel to cooperate and no basis for thinking that that position will change. At most, what will change is Israel saying it's investigating these questions itself, and therefore the court has no real authority by its own statute to proceed. And that would be a prudent possibility, but I think it's unlikely unless there's a dramatic change of leadership in Israel, which itself is probably quite implausible at this point. Let me just say one or two words about the importance of the decision from three perspectives. The first is jurisprudential, which Ioannis has already delimited, and it does confirm the fact that a state can be a legal reality in different contexts, that the definition, there's not one definition of a state, that there are plural understandings of what a state is, and that the UN, by admitting Palestine as a non-observer state, created a certain status that is different from the textbook international law view that a state is in control of its territory and resources and within fixed boundaries. And that issue really seemed quite settled by the admission of Palestine as a party to the Rome Statute. That really was an acceptance of this UN view that for this purpose, Palestine is a state. And the pretrial chamber was very, very careful in saying, we're not deciding for other purposes that Palestine is a state. We're limiting our focus to whether they're a state for the purpose of accountability for crimes committed on their territory. And that's a very limited kind of understanding. And they did the same thing with the jurisdictional question of the degree to which the territory itself was subject to ICC jurisdiction, saying maybe it isn't for other purposes, but for the purpose of assessing these allegations and proceeding with the investigation, it can be treated as appropriately within the jurisdiction of the court. So the jurisprudential determinations are interesting, but not of historic importance. What is of historic importance, in my view, is the second level of the interpretation of the decision, and that is its impact on symbolic politics, what I call the realm of symbolic politics. By reaching the view that Israel has committed, that the allegations of criminality rest on evidence collected over an incredible length of time, 6 years, and Israel being forced into a position of not denying of the substance, but of denying its accountability, it created a very important victory in terms of the legitimacy of Palestinian grievances, that they weren't entitled, that the political defiance was denying the legal entitlement that this judicial body had determined that Palestine deserved. And that will have a very big impact on civil society, even if nothing else happens. Even if the new prosecutor would say, I'll only investigate Hamas's crimes. I'm not going to, we don't have the evidence or the cooperation necessary to proceed against Israel, and therefore it is inappropriate to waste the resources of the court by investigating these allegations that cannot be given a sufficient legal foundation to go further toward the indictment and prosecution and conviction stages. So what's important, and it's very hard to grasp that many conflicts in the world are resolved on the symbolic level, not in terms of who's the stronger party militarily. All the anti-colonial wars were won by the weaker side. And they were won because of the success that the nationalist side had in the domain of symbolic politics. They controlled the moral and legal discourse in such a way that they created a kind of political fatigue on the part of the colonial side that finally gave in, despite being militarily superior. So that's, in my sense, the great importance of this decision from a symbolic perspective. And on the substantive, what can we expect to come from this positive decision to investigate? I would be very skeptical, not cynical, because I believe that there should be an implementation of this investigation. But with the defiance and the geopolitical pressures and the difficulty of gaining evidence without cooperation, and the absolute implausibility of expecting Israel to allow such a decision, if it were to be made, if there were to be a prosecution of some sort, to ever be implemented. It is just not feasible. But that shouldn't lead one to think this is a worthless dynamic for the reasons that I've tried to advance. Finally, coming to the relevance of the Oslo effort to preempt other international formats for addressing the questions of accountability and legality, I think that it's a very hard argument to pursue in a convincing way, because there's so much indication by American political leaders that Oslo was finished and that there is no continuation of Oslo. And certainly the Trump presidency acted as though Oslo was completely irrelevant, as was its underlying rationale, which was to pave the way to a two-state solution. Their approach of the deal of a century completely obliterated the Oslo antecedent. And I regard that as really a red herring thrown in out of substantive desperation, that there was no real way of opposing this decision. And it's sort of clutching at straws that I think are not very tenable. So in conclusion, let me just say that the International Court has done made an amazing contribution to the development of international criminal law and the rule of law generally. And if nothing else, it has placed the most powerful country on the planet on the defensive, resisting in a kind of procedural, formal, legalistic way something that seems so compelling and has been adjudicated in a careful, responsible manner. So I think it's very important that we take this decision seriously and see where it can lead.
Thank you, Professor Falk. This notion of the sort of symbolic politics that it suffused this decision, or that it will make the imprint of this decision so powerful. I'm very interested in that, and certainly on the ground in Palestine, there will be, there already is, an enormous amount of discussion on this topic, and there will be more in the world as things go on. So thank you. So Rania, we're turning to Palestine. I know because of the Al-Haq report and your work that you were prepared to talk to us about some of the facts on the ground and the meaning of the facts on the ground, and the sort of burden of life of being separated by walls and corridors and vast highways, the checkpoints, the blockades, the siege of Gaza and what that has meant in terms of um, absolute abrogation of airspace or sea space or import space or export space that follows from that siege and what life is like there. COVID-19 in Gaza in particular, I know it's been a topic of concern. So these are kind of vast topics, but you have 15 minutes. I do note that both in a very complex and orderly way, both of our previous panelists have legitimately claimed 20 minutes. So I'm probably expecting that if you are doing 15 minutes, you will be playing by the rules, but not actually by the norms of this session. So you take the time you need, but if you are going over 20 minutes, you'll start seeing me, wave my hand, okay? So the floor is yours, and thank you.
That's perfect. Thank you, Dr. Leaning, and it's a real pleasure to join all of you today. I'd also like to thank the FXB Center for Health and Human Rights for organizing this important panel. I think it's really important to have this conversation at this moment, and it's really inspiring to see this recent decision by the ICC prosecutor and to see something move forward in terms of international criminal justice for Palestine. So in my presentation, I'm going to be looking at specific facts on the ground and the question of health and human rights of Palestinians, specifically in relation to an ICC investigation. Just a brief word on Al-Haq. Al-Haq is a Palestinian human rights organization that was established in 1979 to promote respect for the rule of law and for human rights in the occupied Palestinian territory. And the organization has been working for decades to monitor and document human rights violations, as well as to seek justice and accountability at the international level, and in particular at the International Criminal Court. So together with Palestinian human rights organizations, including the Palestinian Center for Human Rights, Al-Mizan and Al-Damir in Gaza, Al-Haq has been actively involved since 2015 in submitting evidence to the International Criminal Court in the situation in Palestine. And over the past 5 years, Palestinian groups have made detailed submissions on suspected war crimes and crimes against humanity committed in the Palestinian context, including in relation to Israel's settlement enterprise, the blockade and closure of the Gaza Strip, and the 2014 military offensive over Palestinians in Gaza, codenamed Operation Protective Edge. In the few minutes that I have, hopefully around 20 minutes, I would like to start with a brief overview of the human rights situation on the ground for Palestinians, focusing in particular at institutionalized violations of international human rights and humanitarian law, and that impact the right to health of Palestinians. And I'll look at widespread attacks on Palestinian health workers, as well as the systematic denial of access to healthcare for Palestinian patients, particularly from the Gaza Strip. And at the end, I will address the potential role of an ICC investigation in upholding the health and human rights of Palestinians in this context. So as you know, the current human rights situation of Palestinians cannot be understood in isolation from a broader context of denial of the inalienable rights of the Palestinian people. The root causes prolonging Palestinian oppression include the denial of the right of return of Palestinian refugees and exiles since 1948, as well as the occupation of the Palestinian territory since 1967 and the illegal closure of Gaza since 2007. In addition, the Palestinian people have faced continued displacement and dispossession on both sides of the Green Line, a policy of strategic fragmentation, which is compounded by restrictions on family unification and severe movement and access restrictions throughout the occupied Palestinian territory, including as a result of the construction of the wall, which the International Court of Justice deemed illegal in 2004. These political forces constitute structural violence, which has detrimentally impacted Palestinian health outcomes. In 2019, the UN Committee on the Elimination of Racial Discrimination found that Palestinians face a disproportionately poor health status, including shorter life expectancy and higher rates of infant mortality compared to those of the Jewish population. The committee recommended that Israel eradicate all forms of segregation severely affecting Palestinians, not only in the occupied Palestinian territory, but also in Israel proper. These stark health inequities have been further exacerbated in the context of the COVID pandemic, particularly with Israel's continued refusal to date to vaccinate all Palestinians in the occupied Palestinian territory, with the exception of East Jerusalem. UN human rights experts have stressed, amongst others, that there's a need for swift and equitable access to COVID vaccines for Palestinians, and that the denial of this equal access to healthcare is discriminatory and unlawful. As we know, since the start of the pandemic, over 2,300 Palestinians have died from COVID in the West Bank and Gaza, and cases are continuing to rise as we speak. So I will talk about Israel's systematic violations of the right to health of Palestinians in the occupied Palestinian territory. These range from the de-development of Palestinian healthcare and the neglect of Palestinian hospitals to attacks on health workers and facilities and the denial of access for Palestinian patients. Critically, in 2019, the UN Commission of Inquiry on the Great March of Return demonstrations in Gaza found, and I quote, that the occupied Palestinian territory is one of the most dangerous places in the world for healthcare workers, end of quotation. During the demonstrations of the Great March of Return, which called for an end to the illegal closure of Gaza and the realization of Palestinian refugees' right of return, the World Health Organization recorded over 500 attacks on healthcare, the injury of over 800 health workers. And during this time, they also recorded attacks on 119 ambulances, 10 other forms of health transport, a hospital, and 6 other types of health facilities in the Gaza Strip. As you know, Palestinian human rights organizations have been documenting violations during the Great March of Return, which falls within the jurisdiction of the ICC's investigation. During the demonstrations between 2018 and 2019, there was 217 Palestinians were killed by the Israeli occupying forces over 80 weeks of protests. Among them were 48 children, 9 persons with disabilities, 4 health workers, and 2 journalists. And the UN Commission of Inquiry explicitly found that there are reasonable grounds to believe that Israeli snipers shot at journalists, health workers, children, and persons with disabilities, knowing they were clearly recognizable as such. The Commission investigated several instances which involved the killing of Palestinian health workers. There were 3 Palestinian health workers who were killed by Israeli forces in 2018, which was the period that the UN Commission of Inquiry investigated. They included the killing of Musa Abu Hassanein on the 14th of May 2018. He was a 34-year-old paramedic with the Palestinian Civil Defense and was shot in the chest east of Jabalia while he was wearing a high visibility civil defense vest, which the Commission of Inquiry found. Around a month later, on the 1st of June, an Israeli sniper killed a 21-year-old Palestinian paramedic, Razan al-Najjar, who was a volunteer first responder with the Palestinian Medical Relief Society, PMRS. There are videos of these incidents that I imagine have come to public attention. Razan was shot with a live bullet in the chest while she was attending to wounded Palestinians during the March of Return east of Khan Yunis, and she was wearing a white vest, clearly marking her as a paramedic at the time. And third, 2 months later, on the 10th of August, the Israeli occupying forces killed Abdallah al-Qutati, who was a 22-year-old volunteer first responder, also with PMRS. He was tending to injuries during the demonstrations east of Rafah at the time, and wearing a white paramedic jacket, carrying a red first aid kit at the time he was shot by Israeli soldiers. So the UN Commission of Inquiry concluded in February 2019 that Israel's rules of engagement for the use of live fire are contrary to international human rights law because they permit the use of live fire against Palestinians in the absence of necessity, and these undermine the threshold of imminent threat to life. The Commission urged in particular that Israel revise these rules of engagement and that they refrain from using lethal force against civilians, including against health workers who don't pose a threat to life. However, as we know, these recommendations have not been implemented, and instead, during the following year, Al-Haq documented 2 further killings of Palestinian health workers, including the case of Sajid Mizhar in the occupied West Bank. Just a week after the recommendations of the Commission of Inquiry were adopted by the Human Rights Council in Geneva, Israeli soldiers killed a 17-year-old volunteer first responder, Sajid Mizhar, in the Haitian refugee camp in the West Bank. Sajid was fatally shot with a live bullet in the lower abdomen from a distance that didn't exceed 100 meters as he was attempting to provide first aid to an injured Palestinian. And Al-Haq published a detailed report of the documentation of his killing. Unfortunately, it did not end here because 3 months later, on the 10th of June 2019, a 36-year-old Palestinian paramedic, Mohammed Al-Jdaili, passed away from injuries he had sustained at the Great March of Return demonstrations east of Jabalia. He was shot while on duty again, and he was wearing an official vest, identifying him as a paramedic at the time. So what these repeated attacks on health workers show us is that there is a broader systematic policy of excessive use of force against Palestinians, and these incidents fall within the purview of an ICC investigation. In particular, we know that willful killing amounts to a grave breach of the Fourth Geneva Convention and a war crime under the Rome Statute. We also know that extensive destruction of property, not justified by military necessity, such as attacks on Palestinian ambulances and health facilities, may also amount to war crimes. A second policy I would like to highlight is the systematic denial of access to healthcare for Palestinian patients throughout the occupied Palestinian territory. The Israeli occupation operates an arbitrary permit regime which severely restricts access to care for Palestinian patients, but generally overall restricts Palestinian movement in the West Bank and Gaza. This impedes access to healthcare and other essential services. In the West Bank, healthcare provision is fragmented due to administrative divisions of the territory and a myriad of movement restrictions, which are made up of the wall, checkpoints, and an expanding settlement infrastructure. These restrict patient access and create unpredictable delays, including for ambulances. As part of this policy of excessive use of force, Palestinians who are injured, for example, by Israeli occupying forces, are often left to bleed to death without access to medical care. In 2019, for example, Al-Haq documented 114 incidents in which Israeli soldiers failed to give medical assistance and first aid to injured Palestinians. Since 2015, we've monitored and documented an increase in excessive use of force against Palestinians, which have resulted in the killing of 704 Palestinians, including 184 children, since 2015 and as of September 2019. But over the past 3 years, so between 2018 and 2020, the World Health Organization recorded 23 different attacks on healthcare, which involved obstruction of access for medical teams where a person had been fatally wounded. Critically, we saw a case that received high prominence that Al-Haq documented last year. On the 23rd of June, the Israeli occupying forces killed 26-year-old Ahmed Ariqat at a West Bank checkpoint. Ahmed was shot with live ammunition by Israeli soldiers and left to bleed to death for an hour and a half. He was denied access to medical care despite the presence of an Israeli medical teams and an Israeli ambulance at the scene. Not only did they not provide him with the treatment that he needed, but they further prevented access for a Palestinian ambulance to reach Ahmed. In the Gaza Strip, as you mentioned, Israel's illegal closure has undermined every aspect of Palestinian life, including the right to health, and it has driven the healthcare system to the brink of collapse. This means that there's an unavailability of essential medicines, supplies, and equipment, and this contributes to the de-development of Palestinian healthcare. The Gaza closure has devastating effects on economic determinants of Palestinian health, which has led to deep poverty and some of the highest rates of unemployment in the world. Israel's permit system is an integral component of the arbitrary closure and illegal closure, which amounts to collective punishment, and it preconditions healthcare for thousands of Palestinians. Yet for many patients, treatment is only available outside of the Gaza Strip, which is subject to severe access restrictions. In 2017, 127 patients are known to have died after Israeli-issued permits to access healthcare out of Gaza were denied or delayed to them. There was even a survival analysis by the World Health Organization, which found that cancer patients initially denied or delayed permits to access chemotherapy and or radiotherapy outside of Gaza were 1.5 times less likely to survive in the following 6 months. The UN Rapporteur on Palestine, Professor Michael Link, found that Israel has been in profound breach of its responsibility with respect of the right to health in the occupied Palestinian territory. As we can see, Israel's discriminatory restrictions on access to healthcare illustrate an intention to punish the Palestinian civilian population, particularly in the Gaza Strip. In addition, the Israeli occupying authorities have in recent years exploited Palestinians' very need for treatment by pressuring patients and their companions to collaborate with them as a prerequisite to permit processing for treatment outside of Gaza. WHO has reported that all patients may be called for security interrogations as a prerequisite to permit processing. Palestinian rights organizations have also documented countless cases of this nature where companions or patients were called for interrogation at Beit Hanun Erez checkpoint in the northern Gaza Strip. Israeli intelligence officers have repeatedly attempted to coerce them into collaborating with the occupying authorities in exchange for accessing health facilities. In a very emblematic case in October 2016, Al-Haq documented the case of 17-year-old Palestinian patient Ahmed Shubeir, who was born with congenital heart disease and had been receiving treatment in hospitals outside of Gaza since birth. He was summoned at the age of 17 for interrogation by Israeli intelligence as a precondition to receiving a permit. He was strip searched and all of his medicines were confiscated during an interrogation that lasted 7 hours. An Israeli intelligence officer told him, and this is documented by Al-Haq, that we know that your health condition is very difficult and are ready to give you the best doctors in exchange for your cooperation with us. Ahmed refused, telling the officer that he preferred to die rather than to become a collaborator. Ahmed's mother as well was then summoned for interrogation and told that her son would die if she refused to collaborate as a precondition to granting her son a permit for treatment. She also refused, and Ahmed died on the 14th of January 2017, unable to access the life-saving treatment that he needed. According to the World Health Organization, from 2014 until the end of September 2020, over 2,000 patients and 800 companions were called for interrogation as a prerequisite to permit applications for treatment outside of Gaza. In 2016, Palestinian rights groups submitted to the ICC prosecutor on the illegal closure of the Gaza Strip, which denies 2 million Palestinians a broad range of fundamental rights, including the right to health, as amounting to the crime against humanity of persecution under the Rome Statute. An ICC investigation into the situation in Palestine comes within the context of pervasive impunity for widespread and systematic rights violations against Palestinians, which are ongoing. In this context, there is an urgent need for international justice and accountability, and the ICC's investigation offers an avenue for the first time to hold perpetrators of serious crimes committed in Palestine to account. At the close of its investigation in 2018, the UN Commission of Inquiry on the Great March of Return compiled a dossier on alleged perpetrators, which it placed at the disposal of the International Criminal Court. The International Criminal Court now provides an avenue to pursue the implementation of the Commission's recommendations. Finally, the ICC has jurisdiction over inhuman acts which cause great suffering or serious injury to body or mental or physical health, which amount to a crime against humanity under the Rome Statute. Ultimately, in this context, the ICC's investigation into the situation in Palestine has the potential to challenge decades of Israeli impunity, and therefore carries important symbolic significance for Palestinian victims.
Thank you. That is a real dossier that Al-Haq has collected with colleagues, and I know this goes back years. So the records of what has actually transpired during the time that the ICC will consider its jurisdiction is pretty dense, and that is that's important from the standpoint of how this case goes forward. So I thank you for this very much. So now we're in the Q&A section, and Rania, you were concise, so we have about close to 30 minutes. We have 30 minutes, and I sent you a list of questions that I might ask you, but and you may have one of those questions in front of you, and you may want to answer it. I'm turning to Ioannis now, and I'm wondering if there is one of those you want to answer. but I have another question for you anyway that's arisen today. And it comes from your mention of there will be a new chief prosecutor appointed in June, which is quite soon in terms of the legal process just warming up now. And can you say, give us some sense of, will that introduce a marked change in tempo? Let's say the new chief prosecutor is not the person that the current one is in terms of her really acute interest in this problem, or is the remit of the court, now that it has taken this on, going to dictate its own sort of inexorable schedule of investigation, pursuing this and that? In other words, is the new prosecutor going to be a significant shift if he or she is less hospitable to this case, or will the internal processes of the court keep it going?
Yeah, so I should preface my answer by saying that I do not, in fact, know, in the sense that I don't have any internal informations in relation to decision-making processes, specifically when it comes to the new prosecutor. But I would say this. So the new prosecutor is Karim Khan QC, who is a British national, who has a long and quite distinguished career in international criminal law and international criminal justice. And importantly, and I think also interestingly, has acted on the defense side in relation to many important international trials, and not just at the ICC. And is, I think, broadly seen as being, and also I would say in the context of the contest for the selection of the new prosecutor, was seen as being very independent and very tough in terms of his position and his program of work. So at least that would, for me, indicate that I haven't seen any indication that would lead us to believe that this new prosecutor will be less keen to investigate matters than the current prosecutor. Yeah, so that's one point. Second point is that I think that it will take a long time. I don't think that there will be an acceleration. I think that it will take a significant time. And I think this is based on at least two factors. The one is that, and you can read that in Fatou Bensouda's statement last week, alongside saying effectively, everybody calm down. She also effectively said, we will begin our task of investigating, despite the fact that our resources are quite limited and that they are currently further hampered by the pandemic conditions. So, the starting point is, she's clearly telling us, just, calm down and wait and let us just start doing that at our own pace and properly, right? Which is, I suppose, fair enough in a sense. The second one, the second factor, I think, relates to the management of this case. And the management of this case is going to be complex at many levels. One is the investigation, evidence gathering, legal analysis, the special difficulties that some of the specific categories of crimes might pose in terms of legal analysis, and the type of inferential analysis that will be required, especially when it comes to targeting cases. And I can talk more about this in a bit. But also when it comes to the type of cooperation and line that the court is meant to follow. So I found Professor Falk's reference to the symbolic level quite meaningful as well. And I think that on some level, indeed, this decision was of fundamental importance, but everything is still up for grabs, as it were, in terms of determining the particular function of this investigation at the symbolic level. And my intuition is that the Office of the Prosecutor will try to act in a particular way that will maintain its status as neutral and removed from certain aspects of the conflict. And in order to do that, it will have to be quite a complex balancing act, both with respect to decisions on prioritization of specific cases and with respect to both formal and informal types of cooperation and communication with all relevant parties. For all of these reasons, I fully expect them to take their time and to not rush into any decisions soon.
Thank you. Thank you for that. We'll come back. I want to give this time to come back to this other topic you'd like to talk, that is sort of the categories of crimes, et cetera. But I actually, and the targeting. Richard, I would like to ask you, this relates to the categories of crimes. There's we perhaps should say at the outset that the ICC is a criminal court, so it will basically address the crimes committed by an individual, which complicates everything in terms of the years we have to cover, and in any sort of government decision to do something. I'm thinking here about the Israeli side, but will be equally buried in the Palestinian side, if not more so. Who actually gave the order, who actually was responsible. I mean, that's going to be, it seems to me, quite a difficult process here. But so certainly please comment on that. But my question is, some of the wrongs that Rania identified, I'm not calling them crimes yet, it's just the very unfortunate things that have occurred and should not have occurred in a normative way that you've described, Rania, would come under a war crime if we were using, the Geneva Conventions, Geneva Fourth Convention, and the whole briefing and discussion that's gone on about the law of occupation. Because many of these activities that the Israelis have been responsible for could be legitimately, I think, considered as a violation of Geneva 4. But it's also the case, though, that there's crimes against humanity, and that could apply in a number of different settings. And my question is, would that also be, or are they going to use different branches of law to apply to different kinds of categories of crimes when it comes before the court? Crimes against humanity, war crimes. Those would be the two I would be thinking about. So do you hear my question?
Yes, it's a difficult question, I think, and maybe very conjectural, because as far as I'm aware, there are no constraints on the scope of investigation that can be undertaken. So there would be nothing to inhibit looking at crimes against humanity as a foundation for indictment of specific individuals, as you suggest. And that's quite important, that point you made at the outset of your remarks, that this court is empowered only to address the crimes of individuals, not the crimes of a state. And in this instance, especially, in a way, both the crimes alleged to have been committed by Hamas and the broader accountability that Israel possesses for behavior at the border with the right of return, and also during the invasion of or the incursion of 2014, it's very difficult to avoid implicating the head of state and the commander of the IDF. In other words, accountability for those policies and the causal link between the behavior, what Rania was talking about, and the legal process that identifies who is responsible, it's the appropriate link seems to me to have to be at the highest levels, and that there's no real precedence in the ICC experience for how that causation will be addressed. I mean, that's a very tricky question always in war crime settings. It's always politically comfortable to go after the lower ranking political and legal, the lower ranking political and military individuals involved, but it would be seen very artificial to do that in the context of this investigation. So how you proceed, again, it's a jurisprudential challenge. How do you frame the issues of accountability in such a way as to create some kind of evidentiary basis for alleging that that Netanyahu and specifically and the commander, including I think Gantz, would be the subject of a criminal indictment. And of course, that would be, again, a huge development in the symbolic realm, even though the prospects of ever getting them in a prosecuting, getting them subject to prosecution is a utopian fantasy, given the way the world is constituted. And so it's a very interesting, you know, from an academic point of view, it's a very interesting undertaking. But again, I think one has to distinguish symbolic importance from substantive prospects. I would emphasize that strongly. And I should say, just as a kind of aside, and particularly because of Rania's participation, that I was involved with this ICC decision because I worked with Al-Haq, two very talented researchers from Al-Haq helped me prepare an amicus brief that I think more or less prefigured the decision that was reached by the pretrial chamber. And I'm very grateful to Al-Haq, and we're doing an article for the Journal of Palestine Studies on the basis of the decision.
You know, we should make the point that there are some phenomenally tough human rights groups active in Israel as well that collaborate and that is coordinate and work in particular instances with the Palestinian human rights groups. So B'Tselem and Physicians for Human Rights Israel. This is an interesting landscape of civil society organizations that operate within their own mandate and constraints, but collectively are building a set of cases and fact pictures that will turn out to be useful, I think. So I work with Al-Haq, relied on their help in understanding what was going on, let's put it that way, back in the first Intifada, when I was involved in my first investigation with Physicians for Human Rights USA then. And so Raja Shahada was then more available than he is now. And it was really an impressive set of interactions I had with him. So I'm going to now turn it, Rania, to you. And I'd like you to be brief because I want to go back and forth a couple of times here with people. If you had to think what were the most 2 or 3 important things you would want the court to address in terms of this litany of misery and possible crimes that you can identify. What would be the 2 or 3 arguments you would like to make based on this fact picture? So I'm not giving you much warning, but give us the mountaintops rather than going deep in the valleys.
I should say one thing before I give examples of what we would hope to see the ICC prosecute. There are certain difficulties, as we already said, in prosecuting suspected crimes committed in Palestine. And the ICC provides an avenue for individual criminal responsibility, but in many ways, the policies that are institutionalized against Palestinians are systematic. So these are systemic and structural abuses that only individual criminal responsibility is not going to address. So we always need to remember that the ICC is not the only avenue at our disposal. It's one of the avenues, and it's very important for individual criminal responsibility, but we cannot pursue it on its own, because by looking at the bigger picture and seeing the nature of institutionalized oppression that targets Palestinians, we need to realize that the ICC may only give us so much at the end of the day. And this is not a pessimistic.
One sec. That's a very important point to make.
Yeah.
And it's it should be what everybody has in mind when they're thinking about the actual reach of the ICC in this setting. If we're talking about systemic or systematic issues, then that is an entirely different body of law or body of public opinion or political argument, etc. I'm with you on that. So you said, but then for the ICC, given its peculiarities and its power, what would you want them to look at?
There are several things we'd like them to look at. I already mentioned earlier some of the different substantive issues that Al-Haq and Palestinian human rights organizations have raised in their submissions. One of the focuses of the investigation that has already been determined by the prosecutor and is likely to move forward is the question of Israeli settlements in the occupied Palestinian territory. And this is really important here. I should mention, I think it hasn't been mentioned so far, but there are certain jurisdictional limitations that we have at the ICC when it comes to looking at suspected crimes committed in Palestine. One is the question of the temporal scope that the ICC prosecutor will have, which is only since the 13th of June, 2014. And as we know, some of these crimes, including the question of establishment and expansion of Israeli settlements, predates that question entirely. And the second thing that we need to remember is that the ICC scope is also limited geographically. Now, it is very important that it extends to the entirety of the occupied Palestinian territory. But what I mean with the fact that it's limited is that it doesn't extend to certain policies that target Palestinians on both sides of the Green Line. And so let's just remember that in the bigger picture, and we would hope that this context within which these crimes are being committed is also remembered when it is examined by the ICC prosecutor. So that would be the first thing, the question of Israeli settlements, the transfer of settlers into the occupied territory, and the displacement and dispossession of the Palestinian people as a result. The second thing that we have highlighted through Al-Haq statements and that my colleagues have worked on in particular is the question of the denial of the right of return. Now, this is a very important question that potentially the ICC could look into, although there could be limitations in terms of how wide the analysis would be, but this is something that we would like to see. And finally, because I mentioned cases from the Great March of Return today, both the question of the Great March of Return and the 2014 Gaza conflict, these are two instances where we've already had UN commissions of inquiry, but we need implementation of accountability recommendations that they have made, and the ICC would be the avenue to pursue this.
Thank you. So I'm back to you, Professor Kalpouzos. You indicated something that you would really like to talk about, which I would like you to talk about, okay? I don't think we covered it in the subsequent round of questions, but also I am reminded by our organizers that there is one question that I think you're positioned to answer, and if not, we can push it towards Richard, I think, but is this issue of complementarity. That is, there have been previous decisions not to pursue certain countries for certain alleged crimes. And perhaps you could talk about that, previous ICC decisions, and perhaps you could talk about that in this context as to why this entire decision by the ICC will not be stillborn, because you've made it very clear, both of you, all three of you have, that it's going to have legs, but that there might be a futility from the standpoint of previous decisions not to take action or not to pursue it.
Yes, I will try to do so, and I'll try to do so as concisely as I can. So I suppose these are related questions in the sense that both reflect the, if anything, the complexity of some of these analysis and arguments, and B, the significant advantage that developed states with developed and sophisticated legal services and judiciaries have in these types of situations. And something which has been reflected in international criminal court practice so far. To start with the question of targeting, and I can refer, I think to some extent this has been touched on by both my colleagues. There is a asymmetry, if you will, or a difference in addressing IDF targeting and addressing, for example, the indiscriminate launching of rockets by Hamas. And that is to some extent reflected in what little we have to go on so far in terms of the prosecutor's statements and documents in relation to this matter, including the preliminary examination, including the application to the court. So, for example, when it comes to the 2014 Gaza conflict, there is not a reference, if I remember correctly, on intentionally launching attacks against civilian population, only on disproportionate attacks. There is a reference to willful killing, but not on intentionally attacking the civilian population. And this is something that very much reflects debates over inferring intention and direct targeting of civilians, in some cases, despite the results on the ground, which might indicate that such targeting was the case. And indeed, when it comes to the first, I think, crime that is mentioned, which is the disproportionate targeting, so the launching of attacks that are disproportionate, this is a notoriously difficult crime to prove, which is reflected on the fact that there are almost no prosecutions in international criminal law on launching disproportionate attacks, and is also reflecting on the relevant subparagraph of Article 8 of the Rome Statute, which refers to a clearly excessive incidental loss of civilian life compared to the military advantage anticipated, which again presses the threshold quite high in terms of indicating some of these violations. Interestingly, also, when it comes to the 2018 Great March of Return, again, if I remember correctly, the specific potential legal basis in addressing some of the killings associated with that incident hasn't been indicated. It was not indicated in the submission that the prosecutor made to the court so far, which suggests that this is something that's open for the prosecutor, as long as everything else is open at this stage in terms of determining the proper legal basis. But in this case, there hasn't yet been a determination of the legal base. And so, yeah, and I think this points, or perhaps provides a bridge to the question of complementarity, in the sense that there has been some practice in Israel in the debate and the discussion and the effort to adjudicate and provide some degree of accountability for some of these incidents. And this practice has been clearly, insufficient, but has also developed particular legal arguments and lines of thinking that are quite innovative in some ways. So for example, when it comes to the 2018 Great March of Return, the Israeli Supreme Court applied a certain analysis which tends to conflate the law of armed conflict and human rights law, leading to a rather permissive understanding of the use of violence that was adopted by the IDF in that particular instance. And the question is whether and how both the OTP, but also ultimately the court, will relate to this type of practice domestically. And as you indicated, past practice of the court suggests that both for presumably reasons of realpolitik, and here we can also relate to some of the points on potential accountability in relation to the settlements policy, but also when it comes to the technical content of the law and the principle of complementarity, the court has deferred to the applications of the law by rather well-established legal systems. So you evoked a decision that was taken a few months ago by the prosecutor to abandon an investigation into a potential UK torture committed in Iraq. And that decision by the prosecutor was criticized, and I think rightly criticized, because despite the virtual absence of prosecutions, despite the fact that a particular team, an investigatory team, was abandoned in the UK, despite clear efforts by the UK government to pass legislation that will make it harder to prosecute such offenses, still, and while expressing concern over some of these developments, the Office of the Prosecutor was unable to find that the UK was unwilling to generally investigate those issues. And the question of exactly what constitutes a genuine unwillingness, exactly how a decision or a desire to shield the defendants is to be inferred and is to be found, is more and more complicated the more sophisticated the domestic legal system and domestic legal actors are in this context. And my, I guess, intuition is that perhaps not openly, but to the extent that Israeli actors will engage on some level with the prosecutor in this process, that particular balance of determining complementarity and deferring to perhaps even nascent rather than ongoing domestic prosecutions will be an important tool in that interaction.
I'm thanking you for your elegant connections between these two questions I asked you, and it does become quite clear now. And certainly Israel has a very developed legal system in many regards, and they have investigated. I mean, they have investigated aberrations and crimes of their own troops in certain settings. So that's an important aspect of this discussion that's going on. Now, we're reaching the end of our time, and what I would like to do is, Ioannis, you have, I think, effectively given your main follow-up, if that's okay. And I'm going to turn to now Rania for a very brief point she would like to make in follow-up to whatever we have been talking about, or a point she hasn't yet made, brief. And then Richard, Professor Falk, could you close the session with your own brief observation or further insight or comment on some of what we've discussed already? Is that okay? I see nods. So Rania, the floor is you briefly, please.
Absolutely. Thanks, everyone. It's been great to listen to all the different insights. I did want to comment on the last point related to Israeli investigations, because I think it's very important to remember that, yes, there have been investigations, but these have not been credible, meaningful, genuine investigations that actually have produced accountability. On the contrary, human rights organizations such as Al-Haq have for years documented sham investigations into the very incidents that I mentioned today. So I think it's just important to remember that it's not just a matter of investigating, but also a matter of whether those investigations are genuinely effective. And we have submitted, together with Palestinian human rights organizations, to the court on Israel's unwillingness to genuinely prosecute crimes that fall under the Rome Statute, so under the court's jurisdiction. And I think that's just something important to remember. And maybe as a closing remark, I definitely agree with my co-panelists about the symbolic importance and implication of this ICC investigation. We hope, and we will continue to be engaged, obviously, as Palestinian rights organizations with this process. We hope that it will genuinely lead to a process of accountability. But we also realize that there are other mechanisms and avenues that will continue to be important for us, including the need for effective measures by states, by third states, such as sanctions, the question of actually prosecuting suspected perpetrators in their own courts, which is an obligation under the Geneva Conventions. So there are certain avenues that we have been promoting for years and that need to go along with the ICC process, which cannot be seen in isolation. And so essentially, what we're hoping to see is real support now for the ICC. Unfortunately, we are seeing a lot of attacks by states on the court and on its process. And among those, I do have to mention, in closing, I do have to mention the continued US sanctions on the ICC. Palestinian organizations and global civil society have been calling for the Biden administration to rescind those sanctions and the executive order that was issued last year on ICC staff in order, of course, to support the ICC process and an investigation moving forward.
That point about the what the Biden administration might do to make null and void the sanctions is an interesting one, which we didn't address. But you're also making the point that there are many other avenues for different ways of investigating and finding redress for what has been going on. And the ICC, as we've just been discussing, is a very particular animal. I mean, and it's an animal we don't actually fully understand in this context. So it's a very, very interesting space to watch as far as I'm concerned. Professor Falk, please.
Good. Very briefly, it's been a fascinating discussion, and I'm happy to have participated. The ICC is not only an animal we don't fully understand, it's an animal that's discovering its own characteristics. It doesn't understand itself. It's an evolving reality, and it's evolving. It has two sets of issues that we've touched on, I think, in the discussion that are very important. One is it's operating within a world of sovereign states. And this whole complementarity issue brings to the fore giving every benefit of the doubt to the state, you know, and the legitimacy and credibility of the ICC, at least at the interstate level, depends on that kind of deference to sovereignty. With regard to civil society, that deference is sort of viewed in a kind of negative way, that people don't trust a formal investigation that doesn't lead anywhere in the context where terrible crimes have been committed. And they look at it as a kind of whitewashing of criminality. So complementarity is to contextualize complementarity is a very illuminating undertaking that people should be alert about. The other thing I would say is that the ICC here is, for the first time in its short lifespan, trying to come up against geopolitical resistance. How will it navigate in those treacherous waters? is and that makes the new prosecutor quite important. He's been given a mandate, or at least the prosecution, the office of the prosecutor has been given a mandate to investigate. The current prosecutor has indicated her intention to open the investigation, but the new prosecutor has lots of discretion. And the question is he going to be a servant of the law, or is he going to be a servant of geopolitics? See, and it could go either way. One hopes that it will go toward, at least tilt toward the law. I mean, there's a lot of room in between those two alternatives. It's not as stark as that. And again, I would underscore what you suggested about Rania's comment that's very important, is the ICC is not the only path to effective remedies for criminal behavior. And we should be open to understanding that it's one of many paths, including the right of resistance on the part of the Palestinian people and global solidarity initiatives on the part of those of us that are outside of either Israel or Palestine. But thank you very much for convening this session, and I hope the project goes forward in a good and encouraging way.
Thank you. Thank you, Richard, for those wise closing remarks and for your good wishes. I think we've had a discussion today that is quite remarkable in that it has ranged widely over a large number of topics. It is dived deep, particularly with Rania, in terms of the issues that are being addressed or may be addressed, or the Palestinians hope will be addressed. It is also dive deep into the intricacies of the law and the courts, and the ways in which this particular court, despite its most extraordinarily dramatic and important statute, the Rome Statute, which is, you know, lofty language. It's very, very important, that statute. But this court gets caught in the ways in which it is dealing in global politics and its own precedents, but more global politics. And so we must view this as an interesting and important foray into the world trying to understand and discipline itself, and perhaps move somewhat in the form that we would call justice. But it's early days yet. But this is also important to note that it is early days into a mode of action that we have not seen. And that in itself is, from my perspective, extremely important from the standpoint of international human rights law and international criminal law. And I'm so thankful to the three of you for being so wise and steady and far-reaching in your discussions, because it opens up and a space for much more sophisticated understanding of what might lie ahead. So thanks to the three of you, warmest thanks. And thanks to you who are listening. And we very much hope that we are going to have some further discussions around this topic and others, and look forward to perhaps even calling upon one or more of the three of you in the months ahead, years ahead, as we embark on these discussions. So thank you very much. And I will actually now call it to a close, and the video and the conversation will come to an end. And all of you at various times and places in the world, because I know it's quite late for some of you here, thank you for your participation. And it's really an honor to work with you. So thank you.
Thank you very much.